Hi, welcome back to the CryptoInvestar Podcast. My name is Daniel Leinhardt. Today I have the tokenization expert, Mr. Reeves Knight. Hi, welcome back to the CryptoInvestar
Hi,
Podcast.
Daniel. Hi, Daniel. Good to be back.
Yeah, I'm so excited to have discussion with you. Um, uh, Today's episode is all about understanding property law, understanding securities law, understanding contracts law, because I saw one of your comments on LinkedIn where you said that tokenization will never replace the legal ownership. That tokenization is simply making a digital representation of a contract, and it doesn't exist without property law for real property and contracts law for all tokens and securities law for all tokens with economic benefits. We also said that tokens are meaningless without appropriate legal framework. I basically want to understand property law, securities law, and contracts law, and the person listening in also to enjoy the conversation and maybe understand it deeper.
Whenever people hear about law as a subject and contract law and securities law and all the rest, it can sound very dry and boring. And I'll try not to make it dry and boring. Suppose the thing is, when it comes to digital assets and tokens and stable coins, because they're all the same thing, everyone focuses on the technology, and which is understandable. It is a technology, crypto is technology driven and based. But the reality is that the technology is just a method of representing something in this case. And before crypto and before Web3, if you had a security, which could be, say, a share in a company or something like that, how did you evidence that you had that share in a company? Well, they used to give you a physical piece of paper called a share certificate.
Yes.
And, people used to hold that share certificate to show that they had a share in that company. Later, with the new technology, they stopped sending people share certificates and they became a digital register. So your name was registered on a computer system somewhere that it owned a share. But that happened many years ago now, but it didn't mean you could do anything with that digital certificate. It was just that it was on a computer now rather than a piece of paper. So technology moved on, but it didn't do much with it. It was still a representation of your certificate. So now with tokens and blockchain, now instead of saying you have a share in a company, you can have a token. But that token isn't really anything to do with the company. It's not issued by the company that you have a share in. What it is it's a digital representation. It's like, in a way, when people talk about avatars, in people who play computer games are used to having an avatar, and which is a representation of themselves in the computer game.
Character. Yeah.
Yep, the character. So it's a representation of you in the computer game. And in this case, that's what really a token is. It's a digital representation of something else. So when people talk about tokenization, and a big feature of that is smart contracts. And they say the good thing about tokens is they can be programmable and permissionless and all this stuff. And that's true because, well, that can happen because of these smart contracts. But smart contracts are not what the name may suggest. They're not technically a legal contract. They are what they are is a digital contract. has programmability and other digital elements, and it can represent elements of a real contract. But a smart contract itself is not a legal contract. It's just a representation.
Can you call it a blockchain contract?
It is a blockchain contract. It is a contract that operates on the blockchain. But what it's not is it's not a legal contract in itself. What it is it's a digital representation of an actual contract.
Okay, legal contract, you mean you cannot present a digital, I don't know, a smart contract. Okay, smart contract details of ownership to legally. You cannot present them somewhere legally.
A smart contract is just a digital representation. It will tell you some of the features of a contract, but it won't tell you all of your contractual rights. And you can't enforce in court a smart contract. What you enforce in court is your actual contract. So when you buy a token, the company that issues the token is called the issuer. And when you buy the token, there is an actual old-fashioned contract, an actual physical contract between the token issuer and the token holder. And that contract will specify the rights that token has. So if, as an example, you have a token, in this case, say a Tether Gold token, to make it a real case. So say you have a XAUT, the Tether Gold token. What it says, if you look at the contractual rights of that token is not that you get paid anything. It says many things, but one of the key features is that you're allowed, that each token represents a physical amount of gold, and you have the right to redeem or trade in your token for that physical amount of gold.
Yes.
And in law, that's called a claim or bailment, which means, it's a legal term, which means that the token issuer holds an asset for you on bailment, which means you can make a claim on it. So you can't enforce that with a token. It's not the smart contract that represents that. It's the actual contract issued by the issuer that every token holder has. Now, that contract can be attached to the token and the smart contract. The characteristics of that can be programmed into the smart contract, but the smart contract itself doesn't do anything without that actual contract being attached. So the token doesn't actually exist without some level of contract.
Yes.
And at the very least, it will be a contract from the issuer which specifies what the actual token is entitled to.
So which means all these tokens that we have right now, they do not have actual contract laws.
They do. So what it is that whenever you issue a token, whenever a company issues a token, and you can see that people say, well, this token could be issued out of Dubai via the VARA regulations, or it could be issued out of Liechtenstein under TVTG regulations. It could be issued from the US under SEC regulations. Every issuing company for a token must issue out of some country. So
yes,
Tether Gold did its first issuance out of El Salvador, as an example. Now, every issuing country has different laws when it comes to tokens.
Yes.
And so there's two things. When you have a token, there'll be two sets of laws that apply to that token. One is what you can call in legal theory public law, and the other is private law. Now, public law is what rights that token has in general, just by being issued from that country.
Mm.
And I'm simplifying this a lot, but I'm trying to give you the main
Yes.
points. And in private law, that would be contract, that represents contract law, which is a private contract between the token holder and the issuer.
Mm.
So I'll give you an example. In Liechtenstein, they have a very advanced set of laws applying to tokenization because they wanted to be, as a jurisdiction, they wanted to attract issuers. And they wanted to offer token buyers, so investors, a very secure set of laws so they know what's happening with their investment. And so they have what's called the TVTG laws, which recognizes very specifically that every token is a package of rights. And so it means that as a token holder, before you even look to the contract between the issuer and the token holder, there's already a set of rights that the token has just because it's issued in Liechtenstein, and the Liechtenstein courts recognize that just by being a token, it has certain legal rights. Now, not every jurisdiction makes that kind of distinction. In some countries, issuing a token sort of falls under very different areas of different legal acts. And it's not so clear what the rights are, except for the contract law rights. So what some countries, and Liechtenstein is one of them, are trying to do is trying to give token holders specific rights, even if the issuer tried to minimize the rights or not give appropriate rights. So it means if something goes wrong, you have more of a chance of getting your money back or claiming against the issuer in certain countries than you do in other countries. It depends on how advanced their laws are. And that's what I mean when I say that these tokens wouldn't exist if it wasn't for regulatory frameworks. So every jurisdiction that token is issued from has a regulatory framework. And it's just a matter of how good that is for each token holder. And it turns out that Dubai is trying to offer token holders a particularly attractive set of laws. Singapore is trying to do the same. Luxembourg is trying to do the same. Switzerland's trying to do the same.
The US?
The US is slowly they're not trying to make it necessarily attractive. What they're trying to do is offer more, and this is a bit of a pardon the pun, they're trying to offer more clarity because until very recently, and I mean October or like late last year, when they actually introduced what's called the Clarity Act, there was a lot of ambiguity in US law about what a token was. Was it, a security? Was it not a security? Which laws should apply? There was quite a bit of ambiguity, a lot of gray areas. And they introduced a new act, but it's only late last year. So they're not trying to necessarily make it attractive, but they're trying to make it clearer what the position is, because they do want to encourage business, and they can now see that digital assets and tokenization and crypto are now becoming mainstream in finance. And so now
Yes.
they want to offer more clarity in how these investments are treated, whereas before there was too much of a grey area.
Mm.
And the EU is ahead of the US in that clarity. They already stated what features a token had to be a security or not a security. So the US is catching up. The US is probably a more complex environment. They've got a really, really big, banking finance sector, obviously, and
Yeah.
they had some resistance from the traditional banks and finance companies to digital assets. But they're getting over that because, for many reasons, it's coming that blockchain in particular, it's not what the DGens said. It's not going to replace traditional finance companies and products, but it will change the infrastructure, and they have to adapt. It's coming to the point now where it's being recognized. Crypto is not just a bunch of guys in basements on their mums on a computer, mining Bitcoin or something. Now they can actually see that the whole crypto and blockchain field is actually going to integrate and replace infrastructure in finance and become part of mainstream finance. So the regulations and laws are catching up.
I think banks working with these tokenization companies, it would even be more sufficient and amazing.
I don't think banks are the answer in that respect directly. What it is that banks are in the business of offering, investment banks are in the business of making investments for people to buy. Whether it's a traditional ETF or a traditional REIT or whatever the financial product is, our banks make money. If they see there's an advantage to offering digital versions of that, which they are slowly coming to see now, then they will start offering that. Yes,
and they already have the physical property and assets to offer.
Well, that's not really yes, that's true. But what they have most of all is trust. Everyone knows them already. Everyone knows JP Morgan. Everyone knows Goldman Sachs. Everyone knows BlackRock. Everyone knows Vanguard. So if they offer a product, they don't have to sell people on the idea that they should invest in that product. People just invest in their products.
Yeah, they are already famous. They have already built infrastructures that they've been using traditionally. The experience, the team, the board, they are really already established. Let's get back to the property law, securities law, and contracts law. Which means, in other words, when you are offering a securities token, it is so different than a person offering just a utility token. Laws are different. Everything's different. You have to pass through very, very different procedures. I think you're offering different products.
Yes. Well, it's again, I'll refer to the Clarity Act, because that's just the latest country and act to show this. But in Europe, it's been the case for a while now. People now look not what a token is called. It doesn't matter whether you call it a security token or you call it a utility token or the issuer. It's really, they look at what's called in a legal sense, it's called substance over form. So it doesn't matter what you make it look like. They look at what is it in reality. And there's a number of what they call in law tests to apply to see, is it this or is it that? But fundamentally, one of the main ones is if you offer an economic benefit like an interest payment or a rental distribution or a yield of any payment of any kind or a profit share, or any kind of economic benefit, then it's most likely going to be a securities token. And if it
Yes.
is, it will usually have to meet securities laws.
Mm.
Now, if you structure a utility token and you want to do rewards and staking and other activities, you can't offer an economic benefit. And so that's one of the main differences between a utilities token and a securities token. The majority, that's the major, I guess, that's the major distinction. Either it's going to be a utility token or a security token. And a utility token will come under I guess, what I'd call lighter touch laws. They may be specific laws to tokens, but they won't come under securities laws, which are the tightest laws from an investment perspective. Whereas if you have a token that offers an economic benefit of some sort, then it's going to fall under securities laws.
But there are some tokens that represent themselves as securities, and at the end of the day, they are doing things that utility tokens should be doing. And in most cases, a utility token is then again doing things as if it's a securities token. And you're like, okay. Or somebody simply launches something like 4 or 5 tokens doing the same thing, offering utility.
Look, the laws that apply will say what a token that can and can't do. The reality is, if people issue a token and then after it's issued change what it does without formally telling anyone or something along those lines, that can happen. And the regulator may not know until someone reports it. Now, someone may not report it.
Definitely.
That's reality still. Like, there's no automatic way for people to, yes, it may be they'll issue a utility token because it's easier, cheaper, and it doesn't have securities laws attached. And then, I don't know, after it's been bought and sold, after a few months, they decide, oh, you know what, we'll distribute some payments through it as well from an investment perspective. And, well, they're not supposed to do that. But if they do, who's going to stop them until someone reports it,
Yes. So securities laws are laws that govern security tokens.
Well, no, securities laws govern securities, whether they're traditional finance securities or tokens. Because what happens is a securities token is first and foremost treated as a security. It doesn't matter that it's a token. So it comes under the investment laws the same as any other security.
Then what about the property law?
Okay, well, property law is only going to affect, as I've said in previous podcasts, is only going to affect a very, very, very small number of tokens, perhaps only one in the world so far, which is the crypto mint
the
one
one
in
you
Dubai.
said in Dubai, yeah.
Correct. Because so far, as far as I've seen, every other property token is really, in reality, either a security token or a utility token, because the owner of the property is a company, and what the token represents is shares in that company, and what you are relying on is company law or contract law, but you're not relying on property law because you've got no ownership of the property.
Wow,
so
that's really amazing. There is a statement you said, and you said tokenization will never replace legal ownership.
Correct, because the token itself is just a digital representation of a right that you have. But the actual, what gives you the actual right is a legal contract. And the token can't replace that at all. When that will be replaced is one day in the future. And that's, again, ties back to what I said. One day we probably won't have tokens, because when assets are issued on chain, like I said before, then you won't need a token, because a token is a digital representation. But when the asset is digital already because it's issued on chain, then you don't need a representation. So whenever there's going to be a token, it will never represent true ownership without an underlying contract. That will change in the future when assets are issued on chain and the blockchain represents fully the ownership. And at that time, the actual claim will be on chain as well. And that's when, all the legal rights will be on chain as well.
Yeah,
but
yes.
We're still a long way from that.
So okay, okay. So let's I've bought my tokens that represent a certain share in a certain company or metal or shares or apartment or whatsoever. But yes, I bought. I used my money and bought, and I'm worth something. I feel I'm worth something. I'm a part of something big, and maybe I get some money off it every single month. But legally, I'm not owning it and I cannot claim it because I'm simply holding tokens that represent that. It means you cannot take a loan with those tokens. You cannot present them as part of your wealth, your worth, your net worth, something like that.
Yes, you can. Represents ownership of shares in a company. That token still has an economic value. And as a result, you paid money for it. And when you sell it, someone else will pay you money for it, depending on what the underlying asset is worth and what that economic benefit is worth. So it's just that what you're enforcing, all this really makes a difference, not when the token is fine and everything is fine. When this becomes important is when things go wrong. So, and things go wrong.
Yes.
So it's only when things go wrong that you then look at, what do I actually own?
Yes.
And so as a result, I'll give you the example because it's real and it's recent. There was a token called Real T, and it was issued in the US. And it's what people would call a real world asset token for property. And Real T, you held the token and you would get every, I don't know whether it's quarter, I think it was every quarter, you would get a payment, which I think was distribution of rental proceeds.
Wow.
Because what Real T did as an issuing company
was it representing something like an apartment or a big
an
hotel?
apartment block. Yeah, an apartment block. But again, like I said before, you owned a share in the company that owned the apartment block. You didn't own a piece of the apartment block, just to be clear.
Yes.
However, the company that owned the apartment block didn't pay taxes on the properties, and number one, and didn't maintain the properties to an appropriate standard for living. And so the city where one of the cities where these apartments were located, which I think was either Chicago or Detroit, I forget, but in a city in America, took the issuer to court for, non-payment of taxes, plus also failing to maintain the properties to livable standards. And I think the total amount of claim in the legal claim was somewhere around 53 million US dollars. And the whole token, all the properties in the token issuing company was only worth 150 million in the first place, I think. So it was like about a third of they were claiming in taxes and repairs and costs, a third of the worth of the token company. So at that point, obviously you're not going to get any more payments because they have to pay fines, they have to make repairs. In fact, it may be possible that the company will have to sell all the properties, or at a loss too, by the way, because it may not have the money to pay the taxes or to make the repairs.
Yeah.
And at that point, as the token holder, you have to ask yourself, well, what do I own? You only own a share in the company, and the contract only gives you a payment based on rental, but if it's available. But if there's no payment available because of mismanagement, because they haven't managed the properties properly, and they haven't paid taxes, and they haven't maintained the properties, assuming they can still keep going, they won't be making payments for a long time.
Yes.
And what you'd be doing is, if you wanted to sue the company, is you would have to take the issuing company to court, possibly, but it would depend. If the contract for the token said, we will just pay you rent when it's available, well, if there's no rent available because they have to spend the money on repairs and taxes, you can't really sue them for that. But perhaps you can sue them for mismanagement. That's a possibility.
Yeah. Which is small. Which is a small case.
So the reality is, all these, no one looks, and this is the problem, no one looks at what their token really represents. Because most of the time, it kind of doesn't matter. When it matters is when things go wrong.
Yes. And I think the real innovation to bring property on chain, it will that solution will come when a lot of companies are failing, mistakes happening, people are frustrated, and then everything comes on chain.
Things will go on chain for many reasons, but even if they went on chain, it wouldn't fix that problem at all. It wouldn't fix what you just said, because just because it's on chain, say the title to the property is on chain, that's fine. But if you own, say you have a true fractional ownership of a property on chain, you spent $100 and now you've got 1.0001% of a property.
Yes.
Well, who's renting that property for you? Who's collecting the rent? Who's going to send a repairman to unplug the toilet when the toilet's blocked up?
Yeah.
Obviously, there's going to be a management company, even if the property's on chain.
Yes.
And so ultimately, how well can you control the management of that company? And as a token holder, how well can you control that? Well, that'll come down to what kind of contract you have with a management company. So the problem with property is it's not a passive investment. It requires actual management. Someone has to
Yes.
collect rent, someone has to make repairs, and so if you go into fractional property ownership, you are still going to have a very similar problem to current token holders. Just being completely on chain doesn't fix many of the problems.
Maybe only claimability, legal position.
I think the only change of going on chain is that all the documentation of the property, which shows taxes paid, utilities paid, repairs made, all the evidence of the paper trail or the paperwork or the records to do with that property will update automatically and transfer with the property and always be visible. That will aid transparency and visibility, but it won't fix the problems of property management.
Yeah, true. That's really amazing. I think today we've had such an amazing episode regarding tokenization, and it's always amazing having you here to, have a talk on what is happening, especially from an experienced view that you bring on this show. It's always amazing to have you.
Glad to have the chat.
Thank you so much. Let me see.
Thanks,
in the
Daniel.
next episode. If you've been listening to the Crypto Investor Podcast, it is available on all audio streaming platforms. Wow, it's amazing